Hello. Happy Thirsty Thursday. Can you guys see me and hear me okay? Hi, Taz Mom. What up? I know I've been MIA the last 2 days. I haven't did I get here at the start? Right on time, baby. Right on time. It's hot. It's hot in California already. It's like 80 degrees here, so I might have to turn on the AC. It might get hot in here. Guys, it might get hot in here. What's up? I've been gone from YouTube the last 2 days, well, from streaming. Your girl's been busy, busy, distracted. But hello, welcome back. Good to see you all. We're going to go over Slender Bean appeal today. It got denied, and it's as much as I don't support Kenzie, but it got denied because her team was a day late. So I don't know how that works. Yay! Thank you, Taz Mom. I appreciate you. You're so generous. Thank you. Gifted a membership, and �61 girl got it. What up? That's awesome. Hey, Miku. Love you, Melly. Thank you. Right back at you. Hey, Angie. Hey, KMV. Perfect time. Yes, I missed you guys. We're making up for lost time. 2 days too long. I got really busy and I had to do stuff with my dad, and then I've been prepping for a lot of lives and dropping videos. Yay, welcome to membership, �60 girl. You're a fantastic girl. Thank you, Miku. We're going to be going through Mackenzie Shirilla's appeal that was just denied because her team was a 1 day late. It's like 10 pages. We'll get through it really quick. And I wanted to revisit the verdict and the sentencing video. Long Time actually just dropped a segment on Kenzie case, and no one is a professional except us babelets here who have gone through everything. So they did a good job though. But let's get started. I'm going to pull up the document. Please hit the like button. Support your girl. Hey, Cree. Hey, KMB. Vanjie. It's good to see everyone. Ramon. Rebecca. Miss B. Miss BB Queen. Oldies. Wait, I thought she couldn't appeal till way later. She got denied. She's denied because they were late. But yeah, she tried. Hold please. I'm here. Oldies. What up? Okay. Let's see. Make sure one of my private information's on there, because. So let's see the date on this. We're going to watch the victim impact statements after this too. So get ready to cry. March 12th, 2026. So I think one of you mentioned it in the chat. Hey Q, what's up? Making paint. Awesome. Okay, let me get started. So March 12th, 2026. Defendant Mackenzie Shirilla appeals. Okay. The underlying conviction stemmed from a high-speed automobile collision on July 31st of 2022 in Strongsville, Ohio. Shirilla, then 17 years old, drove her vehicle at speeds reaching 100 miles per hour before striking a brick building, resulting in the deaths of her passengers. Oh, I already know I'm going to be so annoyed with this. We do have a Kenzie text reading live after this. So how recent it is. It's from this month. Hey, MSM and hey, Dex. Let's see. I already know I'm going to get irritated. Following a bind-over hearing in juvenile court and a subsequent bench trial in the Court of Common Pleas, Shirilla was convicted of 4 counts of murder, 4 counts of felonious assault, and 2 counts of aggravated vehicular homicide. She was sentenced to an aggregate term of 15 years to life in prison. This court affirmed her convictions. Okay. During that direct appeal, the trial transcripts were filed on October 23rd, 2023. Transcripts from the juvenile court bind-over proceedings were later filed on December 15th, 2023. On October 24th, 2024, Shirilla filed a petition for post-conviction relief. In the direct appeal, the clerk docketed the criminal trial transcripts. Okay, the trial court dismissed the petition as time barred on May 1st, 2025, including it was filed 1 day past the 365-day jurisdiction deadline. Shirilla raises the following assignments of error for our review. Assignment of error 1. The trial court erred when it concluded that the petition to vacate or set aside convictions were untimely. An error in calculating the deadline for the filing the petition to vacate for set aside the conviction should be excused. Whether a trial court has subject matter jurisdiction to adjudicate an untimely post-conviction petition is a question of law, which this court reviews de novo. Under this standard, we provide a fresh review of the jurisdictional timeline without deference to the lower court's legal conclusions. Requires a petition for post-conviction relief no later than 365 days after the date the trial transcript is filed in the Court of Appeals. In the direct appeal, the Supreme Court of Ohio has reiterated this deadline is jurisdictional in an untimely petition. The trial transcript trigger. In Shirilla's first assignment of error, she contends that the trial court erred when it concluded that the petition to vacate or set aside convictions were untimely. Shirilla argues the 365-day clock did not begin until December 15th of 2023, when the juvenile bind-over transcripts were filed. The state conversely maintains that the clock was triggered on October 24th, 2023, the date the clerk noted on the docket that the trial transcripts from the criminal trial were filed. The state argues that a trial is a proceeding to determine guilt or innocence, and therefore a juvenile probable cause hearing does not fall under the statutory definition of a trial. Even assuming, without deciding, that Shirilla preserved her timeliness theories for appellate review, Shirilla's petition remains untimely and does not satisfy the jurisdictional exceptions. The court may consider such a petition only if the petitioner shows both the petitioner was unavoidably prevented from discovering the facts supporting the claim, or that a new retroactively applicable right was recognized after the filing deadline or a prior petition, and that for a constitutional error, no reasonable fact finder would have found the petitioner guilty or in a capital case eligible for death penalty. The court may also consider an untimely or successive petition where post-conviction DNA testing, evaluated with all other admissible evidence, establishes by clear any convincing evidence the petitioner's actual innocence of the offense, or in the death penalty case. Turning to the merits, the record reflects the trigger date was October 24th, 2023, and the deadline for post-conviction relief was October 23rd. The Ohio Supreme Court reiterated that the deadline for the filing of post-convictions is tied to the filing of the trial's transcript and the direct appeal. Okay, we read that part. The court emphasized, okay, we already read that. Period begins upon filing of the trial transcript. No later than 365 days. When a period of time is expressed in days, the day of the act, event, or default from which the designated period of time begins to run shall not be included, but the last day of the period shall be included, unless it falls on the public office is disclosed in which the case period extends to the next day the office is open. Let me look something up real quick. I can't believe she's really trying to appeal this, or was. Yeah, they filed one day late. They could not consider her new evidence claims. We're going to review the old appeal too. 1 day late, yeah. Sucks for you, Kenzie. Sorry, I'm pulling something up on Google. Judge Russo still. Shirilla's post-conviction was a 360-day. Okay, yeah. Yeah, that sucks. Accordingly, put aside Shirilla's contention with the calculation was altered because 2024 was a leap year. The 365-day deadline is determined by excluding the transcript filed and counting forward 365 days, including the final day. The statutory deadline is jurisdictional, meaning that a trial court lacks subject matter. Okay, you got that part. In Barker, the defendant was convicted. Okay, so I'm not going to read all of the repeat stuff. Shirilla points to State versus Barker to suggest that a complete transcript consisting of multiple parts may delay the start of the 365-day clock until the final portion is filed. However, Barker is fundamentally distinguishable from the present matter. In Barker, the defendant was convicted following the entry of guilty or no contest plea, meaning there was no trial and consequently no trial transcript to trigger the statute. Because the appeal in that case derived from a plea rather than a trial, the first district found it necessary to look forward the filing of the transcripts that were objectively necessary to the record to determine the trigger date. Hey, trappers. Hey, Gala. She's not getting out in 15 years either. Let's hope not. Hey, Irony, good to see you. Her legal team had an entire year in order to file an appeal that what are the grounds of that? Because I agree with you. Dex, like, can she file? Is there something she can do because they were late? That seems awfully messed up. I don't know. I guess I would have to look that up. Let me see. I'm curious. I mean, would she have to get a different defense team? It says yes, Shirilla can attempt to file further appeals, but her legal options are severely limited. After in March 2026, which is what we're reading now, that the previous appeal for a new trial was filed 1 day late. While her defense team may continue to file appeals, courts have found the appeal petition was submitted late. She was asking for a new trial. It isn't the first time either. What I'm reading here, it says in September 2024, the same court rejected a prior appeal challenging her conviction. I think we read that. Should be on the playlist. Damn. Weird shit. But if they made a mistake, she needs to be in there for life. I agree, Aquarius. You'd think her parents would have been all over it. That's what I'm saying. If you guys know her parents and you have been following the case, you know Natalie Shirilla was not going to let this go. I'm shocked. I'm shook. Both. That they filed 1 day late. This is the second time it happened. Yeah, it did. It has happened. I have 4 different appeals pulled up. I don't know that we're going to get through all of them because we have some court videos. I want to go through the sentencing. I know we've already gone through them, I think, last year, but I want to go through them again. Let's finish this. Shirilla was convicted following a trial. Unlike the scenario in Barker, there exists a definitive trial transcript that was filed October. Okay. The first district distinguished its holding in the Barker case that derived from convictions following a trial. Because a trial occurred here and Shirilla did not seek leave to supplement the transcripts, the specific trial transcript controls the jurisdiction clock, rendering the supplemental juvenile bind-over transcripts irrelevant for the purpose of the deadline. Oh, because they're saying it was leap year. Having established October 24th, 2023 as the triggering date, we must address the impact of the 2024 leap year. Shirilla argues that the anniversary date of triggering event should control the deadline, effectively providing 366 days for filing during a leap year. This argument is misplaced because of a fundamental difference in statutory construction. The General Assembly frequently employs the term, quote unquote, 1 year in other contexts to imply a calendar year period terminating on the same anniversary date, regardless of the intervening leap day. Ooh. In those cases, the computation of time should align with the anniversary date, not the number of days elapsed. A year terminates on the same anniversary date, even in a leap year. The court emphasized that the computation of time should align with the anniversary date, not the day, not the number of days elapsed. Jurisdictional bar and equitable tolling, because the court The trial court lacked subject matter jurisdiction to entertain the untimely petition. We need not to address whether Shirilla waived any of her timeless arguments. In Shirilla's second assignment of error, she argues that any error in calculating the deadline for filing the petition to vacate or set aside the convictions should be excused under principles of equitable tolling or in the interest of justice. This argument is not well taken. Oh. I guess karma's a bitch, right, Kenzie? You're sitting there saying you're innocent and that you didn't mean to kill Dom and Davion, but your phone calls are nasty and your text messages with him are nasty. And we've all heard it. We've all seen it. All of those who have followed the case here, we have gone deep into the Kenzie case. Check out the playlist if you haven't. So, you know, I guess you reap what you sow, and if it didn't work out for you this time, it was for a reason. So I don't know though, on the grounds of like her team messing up, I don't know like if she'll get another chance or she can file for different lawyers. R.I.P. Dominic. Hey Jabril, good to see you. There's too many loops involved in court. You just need a really good lawyer who knows their shit. I would be so mad if I didn't get another chance because my lawyer filed something. Like, I would be so mad. She was constantly threatening him to get what she wanted. I know. Shirilla seeks equitable tolling based on excusable ignorance and the confused state of the law regarding leap year, citing federal habeas cases to support this equitable authority. Shirilla's reliance on federal habeas equitable tolling principles applicable in federal habeas proceeding do not apply to petition for post-conviction relief. Ohio courts have consistently held that a trial court lacks jurisdiction to adjudicate an untimely petition unless the petitioner satisfies one of these exceptions. These exceptions require the petitioner to demonstrate either that they are unavoidably prevented from discovering the facts necessary to present their claim, or that a new federal or state right recognized by the U.S. Supreme Court applies retroactively to the case. Equitable arguments generally cannot overcome clear jurisdictional requirements. State versus Hunley. There's no constitutional right for a petition. Okay. Steve versus Garrett. And State versus Rackley provides two exceptions to the strict authority time limit. If it's a second time too, that's pathetic. Really? We're gonna watch it in a second. The first requires a petitioner to show in part that his or her claim is based on a newly recognized federal or state right that arose after the time limit. The second exception allows a petitioner to file an untimely post-conviction appeal if there are new DNA results in the case, which that doesn't matter here. What she wanted to do was she wanted to have a new trial because allegedly there's more proof and prior bad, what do you call that? Prior bad acts. Like, she's claiming that, you know, she was judged basically in the trial is what she's trying to say, that she should get another shot because of all the stuff, you know, that's out there. It's a new one. The petitioner must also show by clear and convincing evidence that, but for constitutional error at trial, no reasonable fact finder would have found her guilty. Absent satisfaction of these statutory exceptions, a trial court must dismiss a petition for lack of jurisdiction. Here, Shirilla does not contend that she was unavoidably prevented from discovering the facts upon which her claim relies, nor does she assert a newly recognized retroactive constitutional right. Likewise, she does not satisfy the DNA-based actual innocence exception. Because none of the statutory exceptions apply, the trial court lacked subject matter. Finding no error in the trial court's application of the jurisdictional 365-day mandate, both assignments are error are overruled. Judge affirmed. It is ordered that an appellate recover. Okay. That sucks. It's the end of it. Let me look something up. Let me pull up the video. Yeah, her lawyer filed it 1 day late. She was arguing that 2024 was a leap year. She really thought she was going to be able to use that. She should have been given an extra day, she believes. That's crazy. Okay, let's watch. I want to watch the verdict. Wow, her and Letitia want a new child. Good luck. Ugh, I hope she doesn't get a new child. I need to look into that. I've never covered it, but I should. I've followed it, but not covered it. Let's. How did the lawyer not know better? I guess they are claiming the whole leap year thing, which is such bull. In Florida, you have to file for incompetent counsel and file a bar complaint against the attorney, and then it's up to the courts. Oh, I wonder if that's what they're going to try to do. I don't know about Ohio. But why wait the last minute anyways? That sucks.
Let me just tell the judge out here so they know I'm here.
Yeah, it is. Fast forwarding till Kenzie. Ooh, there's Natalie. We're gonna hear her talk.
The off cell phones must be kept away from her so that I can Once the seats are full, seats are full. One has their own seat.
Dun dun dun! Steve and Natalie, our favorites. Oh yeah, right there. I wonder if they think if they talk they'll pick Latin. No.
Not
a corner.
Yeah, one more together.
John?
StreamYard's lagging. Let me know if it's lagging or if it's just me.
Donald needs to come out. We're ready. Just Mr. McDonald.
Oh, wait, I want to go back and see. Whoa, look at Natalie. She actually does not look very happy.
Yes, we do.
Who the hell's Kenzie? Ooh, there's the judge.
Here to the matter of State of Ohio versus Mackenzie Shirilla, 679-612. She's present before today with her counsel in the state of
Put earbuds in if you can't hear it.
Before I render the verdict in the case, I want
Get
to
her.
thank the attorneys for your professionalism and your advocacy in the case. I know it was a difficult case for everyone, including the attorneys and your staff. I also want to thank our 𝗠𝗲𝗹𝗆𝗆. Excuse me. I also want to thank all of the spectators and the media personnel for respecting the trial process. For the families of those involved, I recognize that this trial has been a very stressful event for you, and that stress follows you even when court has ended session. I appreciate that despite that stress, you all worked with me to ensure a safe and respectful environment for everyone here. And although they are not a party to the case, I want to acknowledge the work of first responders to the site of this event. Their diligence and training did save Mackenzie's life. And they tried to save Dominic and Davion, even though they were there too late. In a bench trial, the judge sits as the jury and the finder of fact, as well as the ruler of law. And it is a reminder of just how difficult a job it is to serve as a finder of fact. Whether it's a bench trial or a jury trial, the rules of law are the same. The instructions for weighing credibility and evidence, the admonition to set aside any bias, prejudice or sympathy, and the oath to follow the law as the law is written. These rules of law are incumbent on every trier of fact. I have done what I am sworn to do. I have carefully and deliberately considered all the evidence in this case, including the testimony of the witnesses, the science, the expert opinions offered, the medical evidence, the physical evidence, the photographs, and the video evidence. There is nothing that I can do or say today that will return these two young men to their families. There is nothing I can say or do that will restore Mackenzie Shirilla to the life she had before July 31st, 2022. And there is nothing that I can say or do to restore the lives of these three families before the fateful moments on that day. This trial is a culmination of decisions made by one person, the defendant. Those decisions have forever altered the futures of three families, and of you also, Mackenzie. And your decisions forever robbed Dominic and Davion of the futures that they had before them. If there is one thing that can be taken away from this case, as painful as it is this. Every decision we make is important. Every action we make is important. Regardless of whether the decision is a good one or a bad one, or the actions are good or not, the result is the same. The consequences ripple through time and affect many more people than one might think at the time of the decision. In criminal cases, the state carries the greatest burden under our law, proof beyond a reasonable doubt. As I previously stated, I considered all the evidence presented. And at this point, I would like to comment specifically on Exhibit 802, the crash video. This is the type of evidence you can never unsee. You can never forget the visual or audio of this exhibit. It is chilling and tragic. As you review that exhibit, you know that you are watching the oncoming deaths of two people, and there is nothing that will stop it. The video clearly shows the purpose and intent of the defendant. She chose a course of death and destruction that day. Exhibit 802 crystallizes the deadly decision-making of the defendant. She morphs from a responsible driver to literal hell on wheels as she makes her way down the street. Mackenzie alone made the decision to drive the car to drive an obscure route, a route she visited a few days before, and a route not routinely taken by her.
Look at her.
Mackenzie alone chose the time to make the drive early in the morning, when any reasonable person would expect a few.
What is that? Against all logic, so what is she doing? Trying to cry? No tears. She's a horrible human. I know. This is hilarious.
People would be nearby to witness it or offer life-saving assistance. She made these decisions despite knowing, as any reasonable person would, that her mission of death could have involved others, not even in the car with her. Other people, other cars, pedestrians. She had a mission and she executed it with precision. The mission was death. Mackenzie alone decided to push the pedal to the floor and demand the ultimate speed of that vehicle to 90 to 100 miles per hour. She alone decided what was to be. Mackenzie decided death was the ultimate goal that day, and she alone made that decision for Dominic and Davion, and she continuously acted in a manner to achieve her purpose. Whether or not she intended to also kill herself is a matter of speculation and of no relevance to the weighing of the evidence in this case. The totality of the evidence clearly demonstrates that Mackenzie Shirilla acted purposely and intentionally in the early morning hours of July 31st, 2022. Her purpose was to kill Dominic Russo and Davion Flanagan. No reasonable fact finder could view the totality of this evidence in this case and come to any other conclusion. Her actions were controlled, methodical, deliberate, intentional, and purposeful. This was not reckless driving. This was murder. The court renders the following verdicts. Count one.
Look at her. She's like, oh shit.
The court, having had count one tried to and pursuant to waiver, finds the defendant, Mackenzie Shirilla, guilty of murder, to wit Dominic Russo, in violation of Ohio Revised Code Section 2903.02A, is charged in count one.
Oh my God, look at Steve and Natalie. I had never looked at their reactions. Hey, Ruth Ann. Good to see you. Look at him. Look at Natalie.
The court, having had count two tried to and pursuant to waiver,
Steve.
finds the defendant, Mackenzie Shirilla, guilty of murder, to wit Davion Flanagan, in violation of Ohio Revised Code Section 2903.02A, is charged in count two of the indictment. Count three.
Okay, now I see tears. Now I see tears.
Murder. The court, having had count three tried to and pursuant to waiver, finds the defendant,
Oh my God, look at Natalie, literally in shock.
Mackenzie Shirilla, guilty of murder, to wit Dominic Russo, in violation of Ohio Revised Code Section 2903.02B, as charged in count three. Count four. Murder. The court, having had count four tried to and pursuant to waiver, finds the defendant, Mackenzie Shirilla, guilty of murder, to wit Dominic Russo, in violation of Ohio Revised Code Section 2903.02B, is charged in count four. Count five. Felonious assault. The court, having had count five tried to and pursuant to waiver, finds the defendant, Mackenzie Shirilla, guilty of felonious assault, to wit Dominic Russo, in violation of Ohio Revised Code Section 2903.11 of the Revised Code, is charged in count five of the indictment. Count six. Felonious assault. The court, having had count six tried to and pursuant to waiver, finds the defendant, Mackenzie Shirilla, guilty of felonious assault, to wit Dominic Russo, in violation of Ohio Revised Code Section 2903.11A2, is charged in count six. Count seven. Felonious assault. The court, having had count seven tried to and pursuant to waiver, finds the defendant, Mackenzie Shirilla, guilty of felonious assault, to wit Davion Flanagan, in violation of Ohio Revised Code Section 2903.11A1, as charged in count seven. Count eight. Felonious assault. The court, having had count eight tried to and pursuant to waiver, finds the defendant, Mackenzie Shirilla, guilty of felonious assault, to wit Davion Flanagan, in violation of Ohio Revised Code Section 2903.11A2, as charged in count eight. Count nine. Aggravated vehicular homicide. The court, having had count 9 tried to and pursuant to waiver, finds the defendant, Mackenzie Shirilla, guilty of aggravated vehicular homicide, to wit, Dominic Russo, in violation of Ohio Revised Code Section 2903.06A2A, is charged in count 9. Count 10, aggravated vehicular homicide. The court, having had count 10 tried to and pursuant to waiver, finds the defendant, Mackenzie Shirilla, guilty of aggravated vehicular homicide, to wit, Davion Flanagan, in violation of Ohio Revised Code Section 2903.06A2A, is charged in count 10. Count 11,
Look at Natalie. Literally, I had never paid attention to her in the back.
drug possession. The court, having had count 11 tried to and pursuant to waiver, finds the defendant, Mackenzie Shirilla, guilty of
Is this the lawyer that was late?
drug possession in
not-
violation of Ohio Revised Code Section 2925.11A, as charged in count 11. Count 12, possessing criminal tools. The court, having had count 12 tried to and pursuant to waiver, finds the defendant, Mackenzie Shirilla, guilty of possessing criminal tools in violation of Ohio Revised Code Section 2923.24A, is charged in count 12. The court, having had count 12 tried to and pursuant to waiver, finds the defendant, Mackenzie Shirilla, guilty of possessing criminal tools, and further finds the defendant did intend to use a substance, device, instrument, or article, to wit, a digital scale, to commit the offense of a felony. Sentencing will be 1 week from today, August 21st at 1 p.m. If any party wishes to file a sentencing memorandum, it is to be filed by 4 p.m. on Thursday, August 17th. Thank you.
Love you, baby.
They're like, we love you. Wait, I want to go back and hear Steve. We love you, baby.
Thank you.
Love you, baby.
Everybody drinks this quick.
Let's listen to the. I have access to them, Tia. They're so expensive. I got quoted like it was like $600. So I'm working on it. I would love to get my hands on them. Let's watch the victim impact statements. Oh no, these are sad.
Before we get started, all phones are to be turned off. Members
Look at her demeanor here now.
of the media may have their phones on, but it must be turned to silent. There will be no in and out of the courtroom. Once the proceedings begin, if you do leave, you will not be permitted. Today is an emotional and stressful day for 3 families and for the defendant and for those who care for Davion, Dominic, and Mackenzie. I expect everyone here to be respectful of everyone who's in the room. And if there is any disruptive behavior, I will pause the proceedings and the deputies will escort you out. The court's process will be as follows. I will hear first from the state and the representatives of any of the victims. The court will then hear from the defense and any representatives who wish to speak. The defendant has a constitutional right not to speak. She has exercised that right not to speak at trial, and that right continues throughout this proceeding. She will be afforded the opportunity to speak if she wishes, but that's her choice. Following that portion, the court will deliver the sentence. I also want to advise the defendant that she has a right to an appeal and a transcript at state's expense, and we will assign counsel to represent you.
Not crying here, huh, Kenzie? This is more like the face I expect to see.
Counsel, we have previously discussed and agreed to the following, that the only counts for which the court will sentence today as a matter of law are counts 1 and 2, each of which is murder in violation of Ohio Revised Code Section 2903.02A. Count 1 being the murder of Dominic Russo, count 2 being the murder of Davion Flanagan. Each of these counts are statutory sentences. Each is 15 years to life with parole eligibility after the base term is served, and with parole strictly within the discretion and jurisdiction of the Ohio Parole Board. Each of these counts stands separate and apart from each other, and they can be run either concurrently or consecutively. That is the only discretion permitted to the court in the sentencing today. It is my understanding that we are also in agreement of the following mergers. As to the guilty verdicts against the defendant related to the victim, Dominic Russo, the counts 3, 5, 6, and 9 merge into count 1. As to the guilty verdicts against the defendant related to the victim, Davion Flanagan, the counts 4, 7, 8, and 10 are merged into count 2. That the raping tokes enhancement and post-release control are not applicable to either count 1 or 2. Is that a correct statement?
That's accurate, Your Honor.
Correct?
Yes, Your Honor.
Thank you. I do wish to proceed on counts 11 and 12. It's my understanding on these two felonies of the 5th degree that both sides are waiving any argument. Is that correct?
Yes, Your Honor.
Yes, Your Honor.
And is she waiving any statement on counts 11 and 12?
As to those two counts, yes.
All right. The defendant is sentenced in counts 11 and 12, each of which is a felony of the 5th degree, to 7 months in prison on each count to be served concurrent to each other with credit for time served. Fines and costs are waived. As to the driver's license suspension for counts 9 and 10, the aggravated vehicular homicides, her driver's license is suspended for life. I'm now prepared
Ooh, so even if she does get parole, she can get licensed.
to hear from anybody who would like to speak on behalf of the state. Good morning. Could you start with your name and speak up and speak slowly?
Yes, Your Honor, my name is Jamie Flanagan. I am the mother of the victim, Davion Flanagan. I want to share a small part of what we lost on 7/31/2022. My son, Davion, is and always will be so much more than cargo. He was precious. He was an amazing soul with a heart of gold. He gave to the world what he wanted most in his own life: love. The kind of love that would rescue a friend in the middle of the night, no questions asked. The kind that would protect others and honor them. He made friends easily with his infectious smile. He was a gifted athlete. He had plans to go to barber school and open his own shop. My son did not have a clique of friends, but instead was a friend to all. He would go out of his way to show love and kindness to others, including those that were often cast aside by society, the less fortunate, the developmentally challenged, the hurting, and the unvalued. Davion made sure that everyone that crossed his path knew that he truly saw them, that he valued them, and that they were worth his time. Davion and my kids have had more than their fair share of heartbreak, of hardship, and of loss. Davion was adopted with his sisters from foster care. They are biological siblings. We are honored to be chosen, or to have been chosen, to be their parents. They're forever family. I am devastated by the loss of Davion. The world lost a truly special man. My girls lost their best friend, their protector, the one and only trusted family that has been by their side from day one. This alone, or he alone, understands the pain and loss that they have gone.
You guys, I know most of you guys have been here for this case, but like, just think about it. Like, Davion, what did Davion do? Like, why did he deserve to die? Like, how selfish Kenzie was, I can't even handle it. Weren't they on vacation? I don't know. Oh yeah, they were, I believe. Hey, Rudy. Yeah, I know.
Through and was always there for them. This fact alone breaks my heart for my girls, for my family. So many dreams shattered, a future stolen. We will never get to see the amazing man that he was surely to become.
Like, you guys, what happened? Because she could have done something like, and I'm not justifying what she did, but she could have done something like, I'll wait till we drop off Davion. Like, I don't want to kill him too. I don't know. You know, it's very cold and very calculated. It's vile. I agree.
His life was precious. Like I said, he was so much more than cargo. I pray daily for strength and perseverance for myself and for my family. I also pray that Mackenzie will find true remorse in her heart and true repentance. We thank all of those that worked so hard to help us bring justice for our son. We are forever thankful. Davion, we miss you terribly, but as Christians, we grieve with hope. We will make sure your memory lives on, and we ache for the day that we are united again in eternity. Thank you.
Davion's sister, little sister.
Hello, could you start with your name?
Hi, Your Honor. My name is Davion Flanagan. Davion was my older brother. The passing of Davion Markel Flanagan has been very difficult for me. We have gone through everything together since day one. Davion was a big brother to me and my younger sister, Dalia. We all got adopted together in 2012. After Davion passed away, a lot of trauma and past pain has came into my life, causing it to be difficult to heal from this trauma event, or this traumatic event. Davion was not just a big brother to me, but a role model in many ways. He was the person I trusted the most because he made me feel safe. He taught me the importance of cherishing each moment and enjoying life. The memories we have are strong, but losing him has shown me the value of life. Here's how God works in ways you can't understand, but is worth it in the end. I don't want this pain for anyone else. I don't want people to have to go through this. As an 18-year-old,
Does she look sad? Maybe I just have, like this notion of who I think Kenzie is and who I've seen who she is in those text messages. I wanted to watch these before we go into the text messages. I know it's a lot of feelings here. We're feeling a lot of feelings.
I hate the fact that he is gone.
Whoa.
Because someone decided to take his life. Now that Davion is gone, I feel stuck. I feel as if I can't move forward. I feel lost. He was the one who picked me up when I fell. He was my best friend and the only person that has stayed with me since I was born. I would like you to give Mackenzie the longest possible sentence. I've known her for about 3 years, and as she's always taken the easy way out. You shouldn't be able to take the easy way out when it comes to murder. It's completely unfair that no matter what sentence you give her, she will be eligible for parole, while my brother will be gone forever. Thank you, Your Honor.
Wow. Remember we did the Instagram messages and she says it, her name is Divine. We read some of her messages. Do you remember? We still have to finish those. Maybe tomorrow. Ooh, our favorite, Miss Russo. We love Miss Russo.
I'm Christine Russo. I'm Dominic's
Love the
mother.
Russo family.
No one wanted this to be a murder or to punish Mackenzie Shirilla for this accident. But this was not a car accident. The evidence and science proved that Mackenzie Shirilla murdered my son, Dominic, as well as Davion. There's no fix put in this case, as the Shirillas would like to proclaim. I want to thank Strongsville Police Department and the state of Ohio for seeking the truth behind this crash. Thanks to them, we all know what happened in that car that day. What we don't know is why. I wish I could change this every day. I lost 3 children in that crash. Not a minute goes by
Oh my
each day
God.
that I don't think about my son, as well as Davion. My heart is forever broken. The cries heard from the Shirilla family and friends after the verdict are nothing more than a lack of remorse. Mackenzie Shirilla had a choice. Dom and Davion did not. We are all left here to mourn. But what Dominic and Davion lost can never be remedied in any way or by any particular sentence. July 31st, 2022, I called Mackenzie's mother, hysterical with the loss of my son and Davion. I knew Mackenzie was in the hospital, and the first statement said to me was, "Oh, please don't listen to what everyone's saying on Facebook." Yeah, my son is dead.
Yeah. You guys, we've seen these messages.
His friend is dead, and I'm checking on yours. Yet social media is what's important.
Remember, she was obsessed with the modeling thing. She's a gross poser, I know. Dom loved his mom. Yeah, he does.
Social media has made a game out of the life of Mackenzie and is making a game out of this heart-wrenching tragedy. No one can imagine the pain of losing a child unless they have lost one themselves. The pain is forevermore. Time does not heal this wound. Mackenzie, going to prison because you did this. Be thankful that you're still alive and have a future, whatever that may be. Dom and Davion were robbed of their futures, their hopes, and their dreams. Mackenzie showed no mercy on Dominic, nor did she on Davion. Only God at this time can have mercy on her soul. Thank you.
Could you start with your name, please?
Yes. Should my name? Is there a microphone or anything? Okay. My name is Angelo Russo.
I forgot Angelo testified here too. She'll be home. She better not. I hope she doesn't. I hope she doesn't get parole.
I'm one of Dominic's older brothers, and I'm speaking today for myself and also on the behalf of our siblings and our friends. Sorry. Dom may have been young, but he made the most of each day and had an impact on the lives of his friends and his family. Dom was a businessman, an athlete, a song producer, and an entrepreneur. Dom was not only my brother, he was also my best friend, and the friends in this courtroom also say Dom was their best friend. Many of my brother's interests and goals were centered on learning more about himself and how he could become a better person. He was always doing what he could to learn about others, how he could understand different situations, different cultures, and how he could better the community. He read from various authors every day and even recommended to me countless books that have made me a better person and helped me understand the world better. A few months before he passed, he told me that he soon planned on joining a branch of the military. Admittingly, I was against this, but he felt the need to not only serve the community, but also his country. He gave me countless advice, and he also helped with anything and everything. Nothing said or done here today can describe the loss or repair our lives after this tragedy. Kenzie's statement in the hospital to Detective 𝗍𝗍, "Can't you just take my license away for 10 years or something?" That statement is Mackenzie Shirilla, the most selfish person I know. Ironically, Dom was the most selfless person I know. Mackenzie Shirilla murdered Dom and Davion in cold blood and had already moved on. Kenzie killed Dom over the thought of losing him, and she made Davion collateral damage. She was driving, going to concerts, and dressing up for Halloween, no thoughts of the families and lives that she had destroyed. As I said, Dom read a book every day. He started 2 companies. He recorded his own music, as well as recording music with myself and with friends. Dom helped anyone who ever needed a hand. He was an inspiration to everyone who had the honor of meeting Dominic. We love you, Dom. We love you, Davion. And God bless the both of you. Thank you so much.
Mr. Troop, before you speak, have you marked the letters as exhibits to be part of the record?
I have, Your Honor.
And any objection from Mr. McDonald?
No, Your Honor.
And have you marked your letters?
I have.
Okay, if you would give those both to the court.
It blows my mind that she can take 2 lives and possibly get out. Like, I always think about Jamie case. Jamie should be let out too. I don't think Kenzie should, to be honest. I really don't.
Go ahead.
Your Honor, there's very little that I can say after hearing from those who love Dominic and Davion in regards to the impact that the defendant's conduct had on these families' lives. And we have received a series of letters that have been submitted on behalf of the defendant. In summarizing these, they describe her as a good student and a loving and caring person, and that she could never do something like this. And they continually, despite the verdict,
Loving and caring to who? Someone give me a name that's been here in the through the text messages and everything. Who has she ever been loving to, other than the animals? We don't even know what happened to the guinea pigs, but what?
refer to this as an accident and an unfortunate accident, and tell you that she is also
She was never caring to Dom.
a victim. And there are just a few things that I think is important for the court to consider in determining a sentence today. Part of the evidence in this case and introduced in trial was evidence from the defendant's cell phone. There were search warrants executed on her various social media accounts, her school records, her medical records, things of this nature. And I think that who she actually was is directly contradictory to what is painted by the letter submitted on behalf of her today.
Ooh, I love this.
Do you know how to make the video? One moment, Yari. I'm sorry, Judge, I thought we were starting on this there. Please do it. That's good.
I'm not even cool. I'm just one of those girls that can do a lot of drugs and not die.
I hate that TikTok she made. What is that even? Were we playing that? I should pull it up.
I'm sorry, Judge, I thought we were set on this there. Please do. That's good.
Oh, it makes me so angry.
I'm not even cool. I'm just one of those girls that can do a lot of drugs and not die.
Gotta figure like a pin, I gotta figure like a doll. Don't care if you think I'm dumb, I don't care at all. Can't best sweetie if I want.
Oh, I think I'll get copyrighted for that.
Objection, Judge, none of this is introduced in the trial.
Shortly after the crash, Strongsville police were notified that they had received concerning emails from the community that the defendant and her mother were seeking employment with the Los Angeles modeling agency. Mackenzie Shirilla said to 𝗠𝗲𝗹𝗆𝗆, "Thank you for the comment. I would love to work with you guys. I've been emailing you guys a lot. Such a great opportunity. Thank you."
Is there a date?
There is not a date on this, Your Honor. Based on the investigation, it was delivered to the police while the defendant was still in the Metro Health Hospital. So it was during that time period. She was in the hospital for several weeks. Shortly after being released from the hospital, the police were provided additional videos of the defendant from her wheelchair as she attended a concert down in the Flats. And again, Your Honor, I'm introducing these to the court to show the shocking lack of remorse. This was something that was being exhibited while the investigation was still going on, before she was charged and arrested in November of last year. And these were the sort of things that were coming to the police, and the shocking lack of remorse.
Look at her at the concert with the bra Natalie made her while the investigation was ongoing.
Coupled with the fact that the defendant was reported driving an automobile shortly after this event, that she was seen in Strongsville again driving a car, in spite of the fact that, as her mother testified, she got dizzy sometimes from a condition that she had to take salt pills for, in spite of the fact that it was in fact her mother who provided her with the car that she used to take Dominic and Davion's life. Halloween of last year, again, still before being charged, Mackenzie Shirilla celebrated Halloween with her friends at Ohio University.
That's when she dressed up as Pot. I'm not going to play the music, but it's Afro Man. This was right after the crash. Oh.
Thank you.
And that's when she dressed up as a corpse, but she's trying to say it wasn't a corpse. It was, I can't remember. I know you guys will remember.
Post.
These aren't Halloween of last year, so these would be post-crash, just before she was charged in November. We think the defendant has shown a shocking lack of remorse, Your Honor. We think that she has continually put forward that this was an accident, in spite of the fact that the evidence is in direct contradiction. Your Honor, you were on Progress Drive. You saw the evidence that was displayed in court. And Your Honor, we think that you are the person who is in the best position to decide an appropriate sentence. We have full confidence in the sentence that you'll give her. Thank you.
Your Honor, may it please the court, I ask you to allow Mrs. Shirilla to address the court first.
Oh, okay. So they bring up how she was messaging for Kenzie being a quote unquote model. So now she wants to go up and speak and give a statement. Here she is. Here's Natalie Shirilla.
Can you start with your name?
My name is Natalie Shirilla. I just want to say, am I allowed to address them at all?
Sure.
I just want to say to the families that I'm broken sad and lost, and my heart hurts for everyone, okay? Davion was her new friend, and Dom was the love of her life, and he was part of our family, okay? I'm just so sorry that this happened, and we're heartbroken, okay? And then, Your Honor, this was a terrible, tragic nightmare accident to have happened that she has no memory of, and she will never emotionally or physically recover from it. She almost died too, and we're asking that you please not run the sentence as consecutive. He was family, and we all loved each other. That morning of the accident, she called. I got a phone call that there was a car accident. Okay, so we went to the hospital, and I didn't even.
Why does she keep saying okay? Like, why are you addressing the court like that?
Know who was in the car. The names had not been confirmed yet, and I'm gonna cry because I missed Dom so much. We loved him so much. So I called Dom like over and over again, praying that he was going to answer the phone, and he didn't answer the phone. So then I tried to call his mom, and she didn't answer the phone either. And I still didn't know who was in the car. I didn't even know if she was alive. I didn't know what was happening. So then we were in the waiting room, and then his mom she did call me. So I answered the phone, and I was like, oh my God.
Okay, how do we feel? Are these real tears? I don't know. You let me know. I think she's dressed inappropriately too, Calissa. It's good to see you. Natalie should have never went up there. I know. Something's wrong with her too.
Like, I don't even know who was in the car. Like, what's happening? Was that Dom? And she said, what do you mean? My son is dead. And I was like, I'm so sorry. And then she said something like, and now I have to wait until your kid's out of the hospital. And then I didn't hear the rest. I was like,
okay, so why are you shitting on Miss Russo? This is exactly who they are. Her and Mackenzie.
We loved him so much, and I hung up the phone. I did not talk about social media. I didn't even know what was going on yet. Okay. So then that was it. So in the hospital, that Vitality post, I commented on that because somebody had called her a murderer. Okay. And
because she's a murderer.
She's not a murderer. So she didn't even have her phone at that point because the police had still had it. Okay. So,
what does her being a murderer have to do with her stupid ass cell phone?
So I jumped on and I was like, you know, she's not a murderer. She's more sad than hurt than most of these people commenting. She's been trying to get in touch with you. I mean, at that point, it was just an accident. So I commented on her behalf, not because of the modeling opportunity. Who cares about that? I don't want them to refer to her as a murderer. Okay.
Because we seen the messages, Natalie, that you sent while you were sitting in the hospital with her.
Okay. And I don't even know.
Take some accountability for once in your damn life.
How that commented got on the phone because the police still had her device and she could not access her phone or social media. That's why I did it. And I had called them asking if they could shut down social media because people were calling her a murderer and making death threats and organizing groups to, you know, take her out when she got out of the hospital and stuff. So I didn't even want her phone. I don't care about her phone. I don't care about social media. I just wanted them to stop calling her a murderer so that when she—
But you do, because you just said it yourself. She was in the hospital, so you did it for her. You cared that much that you did it for her. I don't understand how that's supposed to— this is making you look better.
She did come to, and she did come out of surgery, multiple surgeries, that she wouldn't see all these people calling her a murderer because she would never, ever, ever murder the love of her life. Okay?
Okay.
Halloween, for 3 months after the accident, she would only wear his clothes. She would only eat the snacks he ate. She would only listen to the music he wrote, okay? She was laying in bed for 3 months crying. There was a shrine of him next to her with photos and things that he liked and this flower that lights up that he got her because he wanted it to be fresh and alive forever. It's like a little Beauty and the Beast flower. Okay, she's got this shrine of him next to her. So she was crying for 3 months. So her friends asked if she wanted to go out trick-or-treating or Halloween, and it was at OU. And she didn't even want to go. She said, I don't know, should I go? She couldn't even walk yet, barely. So I told her, I said, baby, please go. It's Halloween. You've been laying for 3 months crying, only listening to his music. Please go have just a moment of fun.
Go to a party, yeah. Smoke a ton of weed. Please go. Please do it when you know everybody's watching you. Like, what great advice, Natalie.
Moment of fun. So we told her to go. My husband drove her. I brought her back home. She just needed a second of fun from losing her whole world, So that was us. We told her to go. And that concert she went to with Dom's cousin, Abby, they picked her up. They brought her there. That was Dom, Mackenzie and Dom and Abby all decided to go to this concert together while they were in the hospital. That was for Dom. Everything she did after the accident was either in honor of him, to be close to him, or just to be by him any way that she can. She's like devastated and tragic. He was the air that she breathes. Okay. And they went with.
He was the air that she harassed physically and mentally, emotionally, and sexually bullied the hell out of for 3 years in a row that we were able to read and see. By the way, we have a Kenzie text rating tonight.
His cousin. We spent all kinds of time with him after the accident.
I'm ready to fight her.
What was
we don't condone violence here. We don't condone
I'm hearing
violence.
an awful lot about your daughter. I'm not hearing very much about the two dead people.
Dominic. Okay.
Oh my God. I'm going to try to get in contact with this judge. I love her. How ironic too, her last name is Russo. Like, isn't that perfect?
What was the other thing?
I'm hearing an awful lot about your daughter. I'm not hearing very much about the two dead people.
Dominic, okay, I'm asking you
Oh
for a
my
leniency
gosh.
because this was a tragic accident that she does not remember. And Davion, he's a new friend. I'm so
What
sorry.
does that mean? His life is worthless?
No. God, no, not at all. They all loved each other. They all spent every day together. You know what I mean? I don't know too much for him.
Isn't that part of the problem, Mrs. Shirilla?
Sorry?
Isn't that part of the problem, that they all trusted each other? Isn't that part of
It's not a problem at all. It was
the
wonderful.
problem, how they all ended up in the car together and two of them ended up dead?
I understand what it.
Do you understand? Doesn't sound like it from the jail calls. Okay, fine. I'll back up a little. Like maybe they've changed. I don't know. Forward to 2026. I don't know. I'm not there. I don't know them. Thank goodness. But
It looks like I'm saying that it was a tragic accident. She would never.
Well, we're gonna have to disagree on
I
that,
understand.
right? And I respect your position, but you disagree with me.
I understand. But anyway, that's it. I just wanted to address those. We told her to go to those things, and then she did go with Dom's family. So
this is
look at that.
terrible. Terrible. Why is she doing this?
Don't look at it with look on that with different eyes if you can, please.
Those things are not relevant.
Not at all. But
So then that was what your whole impact statement was about? Trying to defend you texting some scamming model agency?
she's a good, if you would have a moment, all you would need is 5 minutes of a conversation to have with her to learn who she is. Just that you would just need 5 minutes to learn who she is and what she's capable of not doing and doing, and you would see for yourself. That's all. I'm so sorry, guys. I'm sorry.
I love you.
She turns around and says, "I love you" to Kenzie.
She is. Just that you would just need 5 minutes to learn who she is and what she's
5 minutes to read through those texts, huh, guys? How we feeling? Yeah, I know. This is infuriating.
capable of not doing and doing, and you would see for yourself. That's all. I'm so sorry, guys.
Thank you.
I'm sorry.
I love you.
No.
Is there anyone else?
I would like Mackenzie to address the court.
Mackenzie, you don't have to speak if you don't want to. It's up to you. Okay?
Ooh, the judge is like, please shut the fuck up.
You can sit if it's more comfortable, whatever's better for you.
Here we go.
The families of Dom and Davion, I'm so deeply sorry. I hope one day you can see I would never let this happen or do it on purpose. I wish I could remember what happened. I'm just so sorry. I'm heartbroken. I love Dom and Davion. We were all friends and Dom was my soulmate. I wish I could take all your pain away. And I'm so sorry. And to my family, thank you for the support and all the love you guys give. Thank you for fighting with me. I love you all so much. I'm done. Thank you.
Thank you.
She's like, ugh. All right, I'm done.
If I could address.
Was that the best thing you've ever seen in your life or no? Just wondering.
The court should. Your Honor, may it please the court. First of all, I'd like to extend my condolences to the Russo and Flanagan family. I can't imagine how difficult this is. It's terrible. People's acts have consequences, and the consequences here are up to you. You have a range of possibilities as it relates to a girl who was 17 at the time, who is now 19 years old and has no criminal record. And as you so correctly pointed out in the opening, the decision when she gets out is up to the parole board. And we know how the parole board operates, and we know that everybody gets flopped at least once. So a 15-year sentence becomes a 20-year sentence at minimum, and it'll be up to this young lady here as to how she's going to conduct herself for the next 20 years or whatever the sentence would be. That would be number one. Second of all, I'd like to say thank you so much for allowing and taking the time to read those letters. And I would like to concentrate on the letters from the people from juvenile court. First of all, Miss Smith and Miss Kent. They have been the people who have monitored her progress since she was entered the juvenile detention facility, where she was for about 9 months. And I would like to commend them for writing these letters, because ultimately, or initially, I tried to have them send a letter and the people at juvenile court wouldn't let them. And so they sent these letters anyways. And what do we see from their letters? We actually see where both of them say that she expressed remorse during the time. What the prosecutor played there was after the accident and way before she was ever incarcerated. They also both say that they have observed her grow as a person, that she's taken every single class possible, both culinary and college, that she's actually been a model inmate, the letters say, and that she has exhibited what they call the highest level of behavior. They grade people 1, 2, 3, 4. The better your behavior, the higher the number. She has always received the highest number. She's also been receptive to counseling, and as Ms. Kent said, she has been making amends. I'd ask you to pay special attention to the letter from Kelly Leitner that I think talks about certain things. She cites certain things.
He's like, I need to go up there and see what I can do, because they shit on that opportunity with both Kenzie and Natalie speaking.
This Ms. Leitner is asking you to consider that the brain is not fully developed until 25 years or age.
That is true.
Or older. Her choices, Mackenzie's, and actions are indicative of teenage invincibility. While based on your decision, you don't find that. I find that there are. I remember when I was young, the dumbest things I ever did, and I'd hate to be judged for those things.
Okay, I can vibe with that.
So really now I'm going to give you.
I can vibe with that, except how she was treating him in those messages don't prove she was a good person.
My observations, because I understand what you talked with Mackenzie's mother about acceptance of responsibility, etc. All I can tell you is that from the moment I met this young lady here, she expressed sorrow. And I would say during the course of this trial, in the initial emails and statements, she said, I'm sorry for what you did. The prosecutor has said that she hasn't accepted responsibility. Well, as you remember, during the course of this trial, our defense was that it was a reckless homicide. That's taking responsibility for what she believes happened. So I would respectfully disagree with that. I've seen her express true remorse in the times that I met her in jail, and I don't think it's self-serving. And I'm going to say, as an officer of the court, that I feel very confident saying that she has expressed true remorse. So ultimately, another thing that you have to ask for is the likelihood of recidivism, etc. Based upon all of those things, I'd respectfully request that you run the sentences concurrently. Thank you.
there anybody else who wants to?
Yeah, I do agree. I agree with you, Janie. Her age is the only reason I would be okay with parole. Very young.
Don, I'm gonna have to state your honor.
Very young, but you know, the text messages, the videos, the calls, it really does give otherwise, shows otherwise.
Today is the sentencing of the defendant for the purposeful and intentional murders of Davion Flanagan and Dominic Russo. And in a way, it's the second time their families are gathered again to grieve. It's also a day when Mackenzie's family will grieve for the future of their daughter. All three of these families and the friends of these families are suffering, and all of their lives have been irrevocably changed because of the actions of the defendant. The unintended and collateral consequences of a selfish, intentional, and cruel decision by Mackenzie will ripple forever in time. It's literally changed history because it's ended 2 lives. 2 young men are dead. Their deaths were horrible, terrifying, and tragic. I will say again, if any reasonable person reviews Exhibit 802, there can be no doubt in your mind what happened this night. There can be no doubt of the absolute terror of the 2 people in that car. The defendant controlled all the events. She chose the day. Specifically, she chose a day just before her 18th birthday. She chose to drive the car, the time to drive the car. She chose an obscure, previously scouted route through an industrial parkway. She chose the target to hit and the victims. She chose the means and the method to follow through. And she planned and purposefully executed the events of July 31st, 2022. The review of the evidence supports the factual findings, the forensic testimony, the testimony of the first responders, the testimony of the emergency room doctors who treated the defendant, the testimony of the coroner's medical examiner, the testimony of those who knew the victims and the defendant, and the testimony of the BMV official who provided evidence that not only did the defendant deny any medical condition when applying for her license, which her mother co-signed and attested to, but also that just after the accident, Mackenzie renewed her driver's license and again denied any medical condition. In fact, the defendant was so concerned about driving that, as the state mentioned, during the investigation, she asked if they could just suspend her license for 10 years. It is hard to fathom how a person could be concerned about their driving privileges, having just been responsible for the deaths of 2 people. There was no medical condition that caused this as an accident. There was no mechanical failure of the car. The record is clear on the facts and the evidence. Her mother's uncorroborated statements without any medical testimony or records is not persuasive. It is also important to remember that even if Mackenzie intended to also die in this crash, that is irrelevant. A failed
Even if she meant to take her own life, it was irrelevant.
suicide attempt is not a defense to murder. And even in a murder-suicide attempt, when the perpetrator executing the plan survives, the other death or deaths are still murder. There's only one person who's responsible for the pain of everyone in this room, and that person is you, Kenzie. Nobody else is responsible. This isn't the fault of Dominic's family or Davion's family or your family. And I know that each of you have asked your questions to yourselves, what if? What if I had done this or that? The truth of it is, none of us can control the intentions of another. And when there is a purposeful intent to harm or kill someone, it is the perpetrator alone who bears the responsibility for the choice and the consequences and the harm that follows. The difficulty for sentencing today, honestly, is whether or not I believe you should get consecutive sentences. I'm troubled that should I give you a concurrent sentence, that people will believe that somehow I'm being disrespectful to one of the victims. And on the other hand, I have to weigh the punishment. there's a very good likelihood, Mackenzie, that you will spend the rest of your life in prison. That won't be
Ooh.
up to me. That will be up to the parole board, and that will be up to you to a great extent. I understand that the pain in this room wants me to impose the harshest sentence. But I don't believe that would be the appropriate sentence, because I do believe that Mackenzie will not be out in 15 years.
So Miss Russo thinks she won't get parole. I'm not Miss Russo, the Judge Russo.
So she's sentenced on count 2, the murder of Davion Flanagan, 15 years to life. She's sentenced on count 1, the murder of Dominic Russo, 15 years to life, to be served concurrent to each other with credit for time served. I'll waive fines, fees, and costs, and your appellate counsel will be assigned. Are there any questions from the state?
No, Your Honor, thank you.
Any questions?
No, Your Honor.
All right, thank you.
Remember in the jail call when she's talking about her mom was like, "Did you hear us? We told you we love you, Kenz." Anyways, I have a playlist, a plethora of Kenzie videos. If you guys are interested, I wanted to go through the previous appeals, but they're fairly long, and we have text message live literally following right after this live. You should be redirected. I set it up. So let's cover some bases. Tomorrow we're doing a recap on 𝗪𝗪 Fitzsimmons. We've been covering her case. Tomorrow we will be doing a recap with new stuff that has been dropped. She has a trial we're going to cover next week. Should only be a few days. We have, I will go over the appeal. We have Gypsy Live. I'll schedule one to do the old appeals because it's quite long, to be honest. If I read these now, we won't get to the text messages for sure. So I'll schedule another live to read the previous appeals for Kenzie. There's a total of 4, so we can go through them. It'll just have to be a different live. So you should be redirected to the text messages right after this live. Kenzie has lost her opportunity for appeal because of her lawyers, and I don't buy anything we've seen in that court trial. Her parents are so embarrassing. I'm sure they're embarrassed now, but Epstein. Yes, Epstein is tomorrow. I know you've been waiting. I have like 12 Epstein lives, so get ready for it. I've been deep into those, and I was deep into them yesterday too. So yes, we will tomorrow. Tomorrow's like our catch-up day. So shout out to all of you guys for being here and watching that. I wanted to kind of get into the trial and the appeal that was just denied. And now we can go on over to the text message reading. Yeah, I wanted to cover the Afro Man trial, but I heard they were copywriting people on that content. So I'll have to look into it, but I'll look into it and see if we can maybe do, I can find a source that doesn't. That's what I heard. Someone got a strike because of the court content. So I'll check it out. But I repeat, yay! Are you Barbie? We're going to another live now. So we're ending this one, hopping to another one. You should be redirected. Let me make sure. Yeah, it's set up to be redirected. We have a text message reading in just a few minutes. So shout out to all of you guys. It's very important. It is. I agree, Rebecca. Shout out to you guys. Please make sure you hit the like button too. Push me into the algorithm. Push us in, baby. But they didn't. Oh yeah, I saw that. Don't burn yourself out. No, Tia, I was just off for 2 days, so it's catch-up time. I got lots of energy. The Energizer Bunny. Late. Thank you, Are You Barbie? Okay, I'll see you guys soon on the next live. You shall be redirected. I'll see you there.